Hi, everyone. I'm immigration lawyer John Khosravi. Thank you so much for joining us today. We're doing our regular 5 p.m. Pacific time live discussion, talk about immigration, the hot topic being the public charge rule, what's going on with that. We're going to get that in your questions in a moment. I guess I'll just jump into what the hot topic is, which is public charge. So there was this rule that President Trump really pushed into place. The term public charge always existed. This rule hasn't completely been taken away, but it's much more simpler than it was the way the President Trump did it. And it required all sorts of more forms, all sorts of more documentation. That is why President Biden came. There was a lot of lawsuits on it, and they said, hey, you know what? We're not going to pursue this. So I'm going to go into more detail in a second as more and more people come in because we're going to ask about that a lot. But just a reminder, please subscribe, press the like, leave a comment. It helps the algorithm. And just come back. We have a lot of information on our YouTube page, JQK Law Firm, and you'll find a bunch of information there. But with that, let's get it started. All right, everybody, thank you for joining us. So I'll start with getting into what happened with the Supreme Court and the Biden administration. So President Trump instituted this more stringent version of public charge rule, which is a wealth test to see if someone's going to get status in the United States, whether they can afford to be here. And it's very stringent. It required a lot of extra paperwork. It's pretty obnoxious. There are a lot of lawsuits against it. It was going to go up to the Supreme Court again. It had done so before. But just yesterday, the Biden administration said we're not going to continue to pursue this in the USCIS version of the public charge form for I-944. And consequently, it seems like you don't have to submit this. It's done now. You don't have to do it if you're filing within the United States right now. We're still waiting on USCIS to give final word for this. Department of Homeland Security has said they're going back to the old rule. But I would wait for USCIS to do this before you submit a case without it, or you fail to respond to requests for evidence. But we're probably going to know in the next few days. The form is still up online. Now, there's a foreign component of it if you're doing consular processing for a public charge rule called DS-5540, Form DS-5540. That was on hold until the end of December. A higher court said, no, it could go forward, but the embassies really have not started working on it. And if you go online even right now, the form isn't even available. Form DS-5540 online is not even available. So most likely, high likelihood that this version of the public charge rule will not be needed. We'll still do the I-864 affidavit of support if you're doing a case where you have a family-based sponsorship. And the embassies could always, and in the United States, they have discretion to say this person is a public charge because of some issues. But overall, it looks like it's going back to the way it was before President Trump came, which was a good system. If you had a sponsor here, they would say, I'm financially responsible for you. Or if you're employment-based, you have a job. You're going to be working. You don't have to fill out all this extra paperwork and pay all this extra money to do all this kind of stuff. So that's good news. So let's jump to some questions. TikTok about asks, hi, why is USCIS very slow? Well, for the same reason the whole world is slow right now. It's called COVID-19. The pandemic has caused much less people to be able to go to work, and it excludes USCIS employees. And so a lot less people are going there. Funding has gone down dramatically. They blew a lot of money on waste during the Trump administration, so they don't have money to pay contractors. They don't have money to pay overtime. So taking between the intentional destruction of the immigration system by the previous administration, along with COVID-19, the destruction that it has, that put together creates massive delays in processing times, such that are unreliable. Because I'm sure we're getting questions already asking how long my case takes. That answer I just gave right there answers it. I can't tell you how much your case is going to take because first of all, I don't know the details of your case. We have to talk about that in private. But secondly, one case will take 3 months, another takes a year. It's very inconsistent. All I can say is be patient, and that's all we can say. Don't make any big moves until your required case is done. So Real Boy will ask, I have a pending I-130. My spouse died 3 days ago in a car accident. What should I do next? I'm really sorry about your loss. You also say I'm waiting for your travel documents of September. Well, unfortunately, if your spouse dies, your case gets automatically transferred and becomes an I-360 kind of case. If you already have I-130 pending, you should consult an immigration attorney in private, but you become a widower case. And so you need to deal with that issue and submit some extra paperwork if needed, or update USCIS if needed with the death certificate. Just talk with an immigration attorney. They can definitely help you, but you will need the death certificate. But if you had a marriage case pending and your spouse passed away, there is the possibility of saving the green card case. It's doable. It happens pretty frequently. So you got to do that. With regards to travel documents, we have to see what's going on in the case, but you should discuss that with a private attorney. Eduardo says, can you file a 601A concurrently with the DS-260? So no. So let me back up so people know what's going on. If you enter the United States without permission or you overstay a tourist visa, and you overstay to a point where you will be subject to what's called a 3 or 10-year bar if you leave the United States, you will need to submit a waiver to be able to overcome that before you go to your embassy interview. I'm saying a lot of stuff that people who are in the process will understand. A lot of people might not understand. It's more complicated. But the essence is to get this waiver, first you have to get it approved. Then you can file the DS-260, but it doesn't make any sense. So when someone is doing an I-601A waiver for over presidents, first they have to get the initial petition approved. Once that's approved, you can begin a step called consular processing. And for that, you need to submit a Form DS-260 and Form I-6 for all this kind of stuff. But there's no point in submitting that stuff to get an appointment because you need to get the waiver approved first. So you can submit a DS-260 if you want to, but then you're going to submit a 601A. That's going to be pending a year. And then you're going to go back into your case, and all the information you put in the Form DS-260 is going to be outdated. And you have to do it again potentially, or deal with some stuff like that. So there's no point for you to move the consular processing case forward other than paying the filing fees. But you just want the 601A to be approved, then you could jump on the DS-260. What's the rush? Thank you with that. Marlon says, hi, Marlon. Good to hear from you. Ali asks, can I apply for asylum if I've been in the United States for the last 5 years? So I'm not an asylum attorney. I'm not a good resource for that. But generally, there's this rule in asylum that says you have to file for asylum within a year of entry to the United States. Now, there are exceptions to this, and you can get exceptions to it. It depends on your individual case and the individual issues you have. For example, you might be here on a student visa for 5 years, and then you overstay, but then you realize, I want to change my religion. If I go back to my home country, they'll kill me. So maybe you could say there's changed circumstances. Now, that's not exactly a perfect case right there. You should consult an immigration in private, but as I said, I don't do asylum, so I'm not a resource for that. It is possible to file an asylum case even years after, but you have to deal with that issue of not filing within 1 year and be able to argue why that is. So it's not an open and shut case. Petals ask, hi, can someone who comes from India in study package? I'm not sure what that means. I'm not sure what in study package means. So please rephrase your question and let's see what's going on that. Tulsi says, any updates on asylum cases? Well, Tulsi, not really. There's a lot of movements happening. There are changes, but it's very case specific. So you should consult an immigration in private to see if something's affecting your case. That's too broad to just say, oh, this update in asylum happened, because nothing that general has happened. There are little things that happen here and there every day. I have a separate recording. It's for immigration lawyers, but it's to the public. It's called the Immigration Lawyers Toolbox. And I do an interview once a month with a gentleman who's an immigration lawyer that goes to court and handles a lot of asylum cases. The last recording we did about a week or two ago went over 5 detailed in-depth cases. If you're learning for updates, go there. But they're very specific, nuanced kind of stuff. It's not something that probably may affect your case. But if you're interested in asylum and updates for asylum, just check out the Immigration Lawyers Toolbox on YouTube. It's an interview I do every month. The most recent one is with an attorney named Kevin Gregg. Check that out, and that'll answer your question if you're interested in asylum updates. Okay, so Eduardo asks, thank you. It's been a hectic process because I paid the fees for the DS-260, but they expired because we are still waiting for a response for the 601A, so I have to pay the fees again. We have to stay in touch with the National Visa Center to keep those fees alive. So I don't think you have to pay it again. I'm not sure what happened. Hopefully, an attorney it could maybe look into for you, maybe get the money back. I doubt they'll ever give the money back, but now you kind of keep the thing alive and not have to repay if you have a 601A pending, because you're waiting for USCIS, and so they shouldn't charge you again. Just stay in touch with the NVC to avoid that. Pedal's asking, someone who comes from India apply for a student visa? Anyone can apply for a student visa. Your location doesn't matter. It matters if you're really a student, if you're really getting out of school, and if it gets approved. So there's a lot of different factors. Your location being from India itself doesn't make a difference for the case for the most part. Rafael asks, I-140 approved. That's an employment-based immigration petition. You got an RFE, a request for more evidence for I-485, the adjustment of status, the request for the green card, not the proof that you have work, but it's regarding your background. Any thoughts what it means? I didn't receive the letter yet. So, Rafael, you're asking me to read your mind or something like that. If they sent you a letter, we got to see what's in the letter. It could be 1,000,001 things. It's impossible for me to answer that question. So, just when it comes down, when you get the RFE, schedule a consultation, we go through it, but it's impossible for me to guess some random person on the internet asking me a question. That's like trying to have me guess how old you are, or probably guessing how old you are is going to be easier than answering that question. But, thanks for asking. Thanks for coming on the show. You're welcome. Edward Perez says, thank you. You're welcome. So, update about tourist visas. A lot of people ask about tourist visas. You know, it's a messy situation. I did another video, you catch it on YouTube, where I talk about what's going on at the embassy system. Essentially, of all the embassies, only like 40 or so of them are actually issuing non-immigrant visas. Those are temporary visas. These are like tourist visas. And in many countries, like all Europe, Iran, China, there's travel bans. You can't even visit here if you visited those particular areas that I just mentioned. So it may be possible to get a tourist visa. Very unlikely to be able to schedule an interview because the embassies, for the most part, are closed. Some rare cases they may be open. If you're interested, contact your embassy to say, hey, are you open to scheduling this kind of stuff? Could we do it and see what's going on? Or consult an immigration to work your way through it. So tourist visas, they are possible, but right now, most of the time it's not. It depends on the case, the location, the background, the need that you have. If you have like an emergency medical appointment for a special disease that only they know how to cure in the United States, well, we can work and figure it out. The embassy try to get that appointment. But if you're just coming to go to Disneyland and you're from, you know, some countries, from China, from Iran, no, you're not going to get an interview. You're not going to get a visa. Okay, J. Anthony asks, I got a valid green card, but it's been stuck outside the U.S. But I've been stuck outside the U.S. for over a year due to C-19 and airport closure. Can I come back? J. Anthony, I got to talk with you, see what's going on. I can't answer your question here. I got to review your background in private. Mom was asked, any updates on the K-1 visas? Oh, nothing good, really. You know, these are all stalled for a lot of the world. Some world's happening. Each case is different. Some embassies are making mistakes. Some have travel bans. Nothing specific I give to you other than expect delays. Depending on where your case is, you might be able to do a lawsuit to help move it forward. But just like the gentleman person asked about asylum, just any updates on K-1s is just way too broad. There's no broad update. There's very nuanced, specific things that are happening that are depending on your location, the embassy, the facts of your case, if you took part in this thing or that thing. So we'd have to schedule a private consultation to see what's going on with your case to be able to answer a question like that. Pinoya asks, hi, sir, can I travel outside the U.S. with my naturalization certificate while my passport is processing? Well, you know, you're not supposed to really travel or leave the United States even without a U.S. passport. That's the best advice I give you. There's more private stuff we could talk about, more nuanced kind of stuff. Technically, if you bring your naturalization certificate to a land border at the United States, they'll let you in. But if you're trying to fly in and you take a naturalization certificate to the airport in some country, they're just going to look like you're crazy. So maybe if you have a passport that has ability to come to the United States, you're Canadian, for example, and you can fly in, maybe some stuff's possible. But I wouldn't recommend just traveling with your naturalization certificate. You should have your passport. If you really need to travel in urgency, you could contact the passport agency and request an expedited emergency approval of your passport. Rivera asks, for a fiance visa, do you have to send proof right away or after? Remember, your question is not well worded. For a fiance visa, there's 3 different parts to it. There's 2 different parts. Then you have adjustment status. But you have the initial form, which you send evidence about your background and of having met. And then when you go to the embassy, there's separate sets of evidence you have to sit there. Whenever you submit something, you have to give evidence with it. Gar Kerbarovs, weird names, asks, I have a case pending with USCIS and it moved to the National Visa Center. How do I change the address? It depends on where your case is and if you even need to change the address. But if it's with the National Visa Center, you contact them and say the petitioner's case has changed or whoever it is. I need to see what's going on with your case. But if you want to change your address, you contact the National Visa Center through their proper website. They have a page on their website for communications, and you let them know what's up. TikTok says, can I hire a lawyer to expedite my I-485 firm? Well, you could hire a lawyer. You could try to expedite. But expedite, one, depends on why you need to expedite. You can't just do it willy-nilly. You need to have a good reason. And secondly, it's up to the government if they want to prove it or not. So, yeah, it's probably better to have a lawyer look over things. So just be aware, but there's no guarantees, any of that. So I'm going to go back and talk about the public charge rule. We have a lot more questions popping up about what happened. Essentially, there's a lot of cases challenging it. The case about the public charge for I-944, the version that USCIS is doing with Form I-944, was going up to the Supreme Court, but the Biden administration said, you know what, we're not going to argue this anymore. We're going to let this die. So it seems like almost certain that the Form I-944 version of the public charge rule is going to die down. We're going to go back to affidavits of support, the solo I-864 that we had before, and when you're adjusting status in the United States, and a lot of the hardships and harshness of that rule is going to die down in the U.S. Now, the embassy system is different. This lawsuit did not include that. The embassies had a form DS-5540, which some courts have said it's okay at the end of December, but the State Department never has brought the form forward. If you go, it has temporarily, but it's not there right now. If you look at the public charge rule for the embassy's form, the DS-5540, it's not even there. You can't even find it to print it out. So for the most part, it seems like this harsher version of the public charge rule that President Trump put into place is going out. So I want to let you know that you don't have to probably worry about that. But if you have an RFE and you have a deadline, you may want to submit it until USCIS tells us through their website. I always be cautious, conservative, but it looks like it's out the door pretty strongly. But until USCIS announces it and takes the Form I-944 off their website, be prepared. Now, there are still hardships. The public charge rule itself still will exist, and always will exist. But just this version of it that was very hard and very harsh by President Trump and his administration that was made, that seems like it's going out the door and getting good riddance. But the Form I-64 affidavit support and the ability for the embassy, CBP at the border, or USCIS to say this person's broke and they can't take care of themselves, we're not let you in, we're not let you get a green card or the like, is still possible to be there. They always have this authority. There's just a more harsher view of it that the previous administration was taking on. So that's what's going on with the public charge rule. Angel asks, hi, I just had my interview done. My case status shows that the case is in review. What does that mean? It means they're still thinking about your case. It's not abnormal. Sometimes it takes some time after an interview to get a final decision, even if it's a positive one. So you just need to be patient. I haven't been in your interview. I haven't seen your paperwork. You might have had some mess-ups that are crazy and really bad that are problematic. I don't know. But if your case was perfect, this could still happen. So that means there's no answer for you right now. Probably it's going to be fine, but it's not abnormal to get that, even if it's a good case. TikTok asks, does it affect my case negatively if I request to expedite my case? It could cause confusion. It could cause, when you request an expedite, they have to pull up the file, move it here, move it there. It could cause things to be lost, just practical kind of stuff. But generally, no. But practically speaking, who knows? It causes extra movement to have in your case. It could cause the case to move faster. It could slower. There's no real answer to that. Most likely, it's not a problem. But I'm not the officer pulling your case and reviewing it and sending it to some other location. That practically speaking, things can happen. Problems can happen when that switch-up happens. So be prepared for that. Mama asks, will do. Thank you. You're welcome. You're welcome. So yeah, a lot of the cases, when things are outside our hands, it's some third party and some other location dealing with it. We don't know what's going on. We don't know how long they're going to take. We don't know what they're thinking. So there's problems that happen. Sandy says, when will they start issuing the EB-3 visa process? Well, they're starting right now. Now, when it gets to your turn, who knows? There's a lot of backed up cases. So with the removal of the immigrant visa travel ban by President Biden a few days ago, last week, EB-3 and point-based cases, if you're overseas and you want to get a visa, it is open, but it's all practical kind of stuff. Do they have enough staff members to handle that? There's hundreds of thousands of cases that are backed up there right now. When are they going to get to you? We don't know. Lincoln asks, USCIS posted 15 minutes ago on the website saying the new guidelines for public charges is not required at all. Well, thank you so much, Lincoln. I appreciate you for mentioning that. I checked the DHS site, which says they're going back to the 97 rule. I hadn't saw it on USCIS, so I guess the public charge rule is gone if you're processing in the United States, and most likely, very, very high likelihood, if you're doing consular processing, the Form DS-5540 hasn't been used, and it won't be used. But again, it could be strict. I've seen, even before all this kind of stuff, the embassy in Mexico, Ciudad Juarez, sometimes just reads into the statute, makes up things with public charge rule. I've seen colleagues get denials incorrectly. For example, they brought a joint sponsor to satisfy the public charge rule, Form I-64, and they said, we can't accept joint sponsors. Like, what the hell? It's in the rules. You could do that. So it is discretionary. That was probably a mistake to get people involved, try to fix that. But good news, Lincoln. Thank you for sharing that. I hadn't saw the USCIS post on it yet. Thank God, hallelujah. We don't have to do this from I-944. It created many hours of extra work, hundreds of thousands of dollars of extra costs, thousands of dollars of extra costs for clients. And I don't think it did anything to help, the idea that, people are broke, they can't. That form itself didn't help out. We had the affidavit support where we had a U.S. person sponsoring it and being financially there. That was all that was needed. That was a ridiculous request situation that was added by the previous administration. So Petals asks, I have received my work permit, but not received the interview yet. I-589 asylum and withholding removal. Okay. Then you just gotta wait for your interview to be scheduled, and that's that. Well, you got your work permit. At least you're hanging out. Court is backed up right now, so just gotta wait. Garcebroth asks, I-130 in process. Bringing my wife from Italy. How do I change her address if she moved on USCIS NBC? If your wife's overseas, at this point you don't need to change it with USCIS. When you're filling out the forms for the National Visa Center, put the new address in there. And if you like, contact the National Visa Center through their forum page and say, hey, the applicant's beneficiary applicant's address has changed. FYI, put that in your system if you need it, but primarily in the form DS-260, update the information. That should be fine. Jose asks, why is my receipt form say Potomac, but the online service says Nebraska? None of this makes any sense. So when you get a receipt, it might say for a filing, it might say where the location case are processing in. But I found mass inconsistency where they'll say it's processing in Nebraska, and then I get approval notice from the California Service Center. It's in Texas, and then Nebraska comes. There's no consistency. I have a case right now I was looking at last night. It's a I-130, a woman, a U.S. citizen, filed for her father. When I go online to check out the average case time, it says this cases are done in like 10 months. Her case is pending a year and a month. So I'm like, okay, let's file a complaint. So I went to file a complaint. They're like, no, your case is within regular processing times. But I'm like, what do you mean it's within regular processing time? Your own website said it's not. And so we go back and forth. No, we can't help you. So don't rely on logic and consistency when it comes to this kind of stuff. There's no real answers because it's a huge mess. So that's all I can say about that, Jose. But thank you for your question. Claudia says, I hope they let family members wait in U.S. while processing like asylum and refugee. My fiance and I will get married soon and start K3. Okay, good luck. Yeah, hopefully you'll be able to come and wait. Claudia, I hope you weren't separated from your loved one for any longer. Pinoy asks, sir, follow-up question. I'm a dual citizen. I have my passport for another country, but since I just applied for my U.S. passport and what I have right now is only the naturalization certificate, then I don't know what to tell you. I mean, you're not supposed to travel and kind of come back to the United States. If you're a citizen without your passport, you got to do what you got to do. If you want to schedule a private consultation, we could go in more detail about it, but that's all I got here. Blaze asks, hi, can my I-485 interview based on marriage be approved without a joint account? My wife is pregnant. You don't have to have joint bank accounts when you're doing a marriage case as proof of relationship. Now, it's better that you do. A lot of people a lot of officers find it important, but there's other ways of showing it. For example, if your wife's pregnant, you go to the doctor, maybe there's some notes that list who the father is, or maybe you've been on flights together, you travel to places, you have photos together, you have a joint lease agreement, joint car lease, or health insurance together. There's all sorts of other ways you could prove your relationship for a marriage green card case. Just having joint accounts. Not one of them. I was having a consultation last night with clients, and they didn't want to join their accounts. Now, we know each other's finances, but we're keeping it separate. I said, okay, what else do you have? Okay, they went on a bunch of trips together. They have photos with family and friends. They have letters they're going to get. They have car insurance together. They have health insurance together. They have 2 or 3 more things. I said, okay, we'll do that. You go for an interview. You be yourself, and you'll be okay. You know, in your case, you probably have your kid. God bless. By the time the interview happens, bring the birth certificate of a child. That could go a long way. Lincoln, you're welcome. Ask the person that helped me about the update about USCIS and public charge rule. Says, I've been checking all day for updates and guidance. All details are posted if people are able to refer to the website for it. Wonderful. Thank you, Lincoln. I appreciate that. Jose says, thank you. You're welcome. TikTok says, can I work while my work permit is expired? No, if you don't have valid work authorization, you can't work. And now there's some exceptions where if you had a work permit, you filed a timely extension. In some types of cases, you will be allowed to continue work, but generally you need to have a valid work permit. Pinoy says, thank you. You're welcome. Ardit asks, hey there, John, can I expedite my I-765, that's the work permit, before getting biometrics appointment or not? You know, I think I used to be able to do that, but remember the last time, 2 years ago, I asked to expedite a work permit. They said, you haven't done your biometrics yet, we can't do that. So now first we asked them to expedite the biometrics appointment, and once you get that, then you request an expedite of the I-765 work permit. That's the way I'd go about it. Paulina asks, how long is the request for FOIA taking? Well, Paulina, there's 50 different types of FOIA requests, and it depends on what you're requesting a document. So there's no consistent answer what you're talking about. If you're doing USCIS, it takes several months to say the least. I've seen it take a year. If you're doing a CBP, the Port Authority, sometimes they don't even answer. If you're doing with EOIR, I haven't done one for over a year, but it used to be like 30 days. There's FOIA requests you can do from every government agency. Sometimes you have to file a lawsuit to get the information from them. So, Paulina, schedule a private consultation to see what your situation is and what you need the FOIA for and see what's appropriate and get estimates of the time, but they're not reliable. Pejorat says, hello, sir. Thank you so much for watching. I want to thank everyone who's joined us. And, if you're thinking about doing a marriage case, download the Ultimate Marriage Green Card Guide at www.marriageimmigrationlaw.com. That's marriageimmigrationlaw.com. I did the Ultimate Marriage Green Card Guide. Talks about fiance visa, marriage visa, all this stuff associated with it. I'm going to have to update it to take off the public charge form I-944 stuff that's in there. But other than that, it's there. You have sample questions of how to prepare for an interview that you may be asked, sample translation certificates, sample affidavits and declarations. It's worth $50. It's worth $5,000, frankly, because they teach you how to do a case essentially. But you should consult an attorney after you read that to get specific guidance as to your case. But it's a good first step to realize and understand what the marriage green card process looked like. And in reality, it overlaps with employment-based green cards and all other types of green cards, not just marriage cases. I just market it in that way. So it's something good to download to get an idea of how the green card process is. There'll be some nuanced differences, but you always should consult with an attorney in private for guidance on your individual case. So we got a couple minutes left. Let me ask one or two more questions, and we'll call it a day. Marlon asks, "Hi, I filed I filed from September 29th. I received my receipt notice November 4th. They received my case October 5th. And still no biometrics." Yeah, the biometrics are delayed. Just be patient. I've done a lot of videos on YouTube about this. You got to wait. Biometrics are super backed up. Could be 8, 9, 10 months. So again, you got to be patient. Receipts are taking months. You got to be patient on that as well. Those are taking forever. It's a really bad situation when it comes to delays with USCIS, the embassies, everywhere you could deal with immigration. It's backed up and problematic. And that's just a situation that we're dealing with. So what else is going on? If you did want to schedule a private consultation, just send me an email. My email is info@jqqlaw.com. That's info@jqqlaw.com. And we can schedule a private consultation. Fees do apply. But to start, just email me and let me know what the issue is so I can know what's going on with your case. And then if it's something I handle, I'll let you know, and I'll let you know what's going on next. If it's something I don't handle, I could always try to connect you with a colleague if I know somebody is appropriate for it, and we can take it from there. Abu Sufyan asks, "Hello there. My marriage green card interview was a month ago. I was approved on the spot, and I was told to receive a green card within 2 weeks. I haven't heard anything back and no online update. Yeah, try writing a letter to the officer to handle the case. Of course, the follow-up. Sometimes that stuff happens. It's not unheard of. I've seen that happen before. But that's that." Yusrallah says, "How can an applicant who has a VAWA transaction obtain implement card?" Yusra, your question is there's some errors in the wording you're using, so I can't really answer that. I'm not sure what an implement card is, and I don't know what you mean by VAWA transaction, so you gotta give me more detailed. Jose asked another question: "Is it okay for my wife to visit me to USA with her current tourist visa?" I don't know, Jose. That's individual legal advice for your wife. I need to know everything about the case to give general guidance. Even then, entry into the United States is up to the port authorities, CBP, Customs, so it's up to them. But that's too case specific. I'd have to meet with you in private with you and your wife to discuss your case, see what's going on about that one. Afsar says, "Can you give information about the citizenship test?" Yes, President Biden brought the citizenship questions, the civics questions about U.S. history and the like, back the way it was before. 100 questions. You get 6 out of 10 of them right, and you're good. Just practice those. Now, there's other things that go on in citizenship, going into your background, all that kind of stuff. That's a case-by-case analysis to see if there's any issues that could pop up during citizenship that could cause you to, get the citizenship denied, potentially even lose your green card. So there's a lot of stuff going on there. Ivy Marie asks, "Hello, sir. Is it now confirmed we don't need to file Form I-944 according to the USCIS update?" One person here posted that USCIS officially said you don't need Form I-944. I haven't read it myself because I've been live here. I haven't had a chance to bring it up. But it's very, very, very likely that I-944 is gone. Maybe I'll just check it right now when we're talking. I-944, USCIS. Just look on Google and see what it says. I'm going to the website for I-944 Declaration of Self-Sufficiency. The form is not there. I guess that means I-944 is dead. Good riddance, but let's see if there's more stuff. So I'm just going to go to uscis.gov, and it should be on their homepage, something important like this. Recently, they updated the website to make it harder for you to get information and news. And the USCIS website, DHS Secretary of State. So the Secretary of State for DHS has said they're going back to the 2009 version, but USCIS itself, I don't see it, but we did have a person here that said it's on the website. But you could most likely, you're going to hear more and more about this because it's such a big deal. Very, very likely that Form I-944 is no longer needed. And on that happy note, I want to thank everyone who joined today. We're going to have to call it a day. We hit the 30-minute mark. I'll be back here again next Wednesday, 5 p.m. Pacific time, and we'll jump into it and answer your questions. In the meantime, if you want to schedule a private consultation, just email me at info@jqklaw.com, and we'll get down to business and see what's going on in your case and what we could do. Until next one, God bless and be safe. Thanks for joining.